and welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and this is a weekly video segment that is an extension of our monthly newsletter called Sidebarred. And if you're not familiar with that, that is sound information designed to educate you beyond a reasonable doubt. And you can sign up right down here and get that right in your inbox on a monthly basis. We promise not to spam you. But in the meantime, this week's topic is about or is geared toward you do-it-yourselfers out there, just to make sure you understand the differences between filing a petition in the probate court if for that loved one that passed away, if you're in that position to be that personal representative of that estate. There are two different routes to go. One if there is a will in place for that decedent, that person that passed away, or if there's not a will in place. And so let me start on my right side. If there's not a will, then you're filing for letters of administration to be the administrator of the estate. And if there is a will, there are a couple different ways on this side, but you're filing to be the executor of that will, to execute what the final wishes are of the will and to handle the affairs of the estate overall. So both processes are very similar, but I just wanted to provide this informational segment to let you know that at least here in Georgia, there are different forms for those different circumstances. And in the end, you'll either get issued over here letters of administration without a valid will, or letters testamentary if there is a will. And what that is, you may find that you're dealing with companies or organizations on behalf of the estate that will request letters. And all it is really a one-page document. I don't know where that term originated from, but it's a one-page document that you end up getting that just gives you the authority from the court to handle the affairs of that estate. If it's letters testamentary, it gives you the authority from the court to execute the wishes of the will and to handle the affairs of the estate. So I just wanted to make that clear. You want to make sure you're submitting the right form when you're filing these different petitions with the courts, particularly with the probate court in the case of what I handle, because technically the clerk's there and neither can the judge give you specific legal advice. Now, some of them are helpful. Well, most of them, if not all of them, are helpful, but they can only be helpful to a certain extent because by law they're not allowed to give you specific legal advice because they're not attorneys. The judge is, but not the clerks there. And the judge has to stay impartial, so the judge can't give you legal advice either. So keep that in mind when you're filing. And if you have any questions, you can always contact your wonderful estate planning attorney to help you through that. I do offer coaching services as well. So if you don't want to pay the slightly higher fee for me to do the whole package for you, then I can certainly set up a consultation where I'm reviewing what you've already done or making sure you're at least filing the right form in the right court and that sort of thing. So I look forward to any questions you may have in the future to include in future Wednesday Wisdom videos, or any questions in general related to a specific situation or circumstance that you find yourself in right now. But as always, thank you for watching, and we'll see you next time.